motions to dismiss, motions to stay, and new claims added to the Clemson filing. We have a lot to talk about.
The ACC lawsuits are always in the news, so we're back on the big mountain to keep you updated.
Hey, it's great to have you back here on the mountain. I am JY. This is my good friend Steve. And Steve, we dropped an episode 2 weeks ago about Clemson. There wasn't a whole lot going on, but we told our viewers, be on the lookout for early May because there's a lot of deadlines coming. And my goodness, every day they're putting new stuff up on the website. It's crazy. So I got through a lot of this. Well, I'm going to go over this. First, I'm going to separate it out between Pickens County, South Carolina. We'll talk about what's been filed there. Then we'll talk about Mechlenburg, North Carolina, and what's been filed there. And I'm going to do it chronologically. So we're going to have to go back till April 17th, which was actually just before our last episode here. But Clemson amended their complaint in Pickens County and added 4 new claims, or cause of actions as they call them, to their case. They originally had 3. Now they have 7. The 7th being the most interesting. So that's the one we're going to focus on. If you've seen any of the headlines, that's the one that's getting the most headlines. But I want to talk about all of them real briefly. So the fourth cause of action is that Clemson is not in a joint venture with the ACC. The ACC claims that as a member of a joint venture, Clemson has a fiduciary duty to the ACC. Clemson asked the court to declare that there is no such joint venture. We heard what Judge Bledsoe had to say about that in Mecklenburg. They're adding this here saying, they know what that judge said in a North Carolina court. They're kind of using that now to amend this and say, hey, there's no such thing. Forget this whole fiduciary duty responsibility that we have to the ACC. So not a surprise they added that. The 5th cause of action, one of your favorite things here, Steve, they asked the court to declare that Clemson has sovereign immunity from the ACC claims, a big item we've been talking about over and over again with FSU. The 6th cause of action, there has been no violation of the grant of rights agreements. And then the 7th cause of action for damages, that being slander of title. So we've said all along how much Clemson is kind of keeping it vanilla, so to speak. I mean, we're in a lawsuit, yes, so there's going to be some of this happening, but they really haven't gone on the attack for the ACC. But now they're claiming that the ACC is making false statements and slandering the name of Clemson. So let's dig into this one a little bit more, because this is, of course, salacious. Yeah. Clemson says that the ACC's false statements regarding the grant of rights have perpetuated a misconception to the detriment of Clemson University. Specifically, the public declarations that Clemson's media rights are granted to the ACC through 2036, regardless of whether Clemson leaves the conference. They state that the media have repeatedly and mistakenly reported the irrevocable granting of the media rights to the ACC, even for games played when they are no longer member of the conference. This public misconception interferes with Clemson's pursuit of opportunities with other collegiate conferences and media providers. Diminishes the value of Clemson's media rights, which in turn injures Clemson University and impedes their ability to negotiate future media rights agreements. They believe that these misstatements by the ACC were made with malintent to harm Clemson and deter its exit from the conference. Clemson has suffered special damages as a result, including impairment of their intangible property and the cost of litigation. Clemson is asking for damages, including punitive damages, as a result of this slander. So let's stop there, because that's probably the beefiest one that we're going to have. Or there's some other interesting stuff we'll get into, but this one's interesting. What do you think about this? Well, let's start with, what do you think about their case of these kind kind of misreportings and what they've been throwing out there. I think that's certainly known. And then what do you think about how Clemson is now saying there was malintent and they did this on purpose, and now we're owed damages because you've slandered our title. So what do you think about all this?
Yeah, so dive right in there. Here's the thing: is that the ACC and ESPN have fought really, really, really hard to keep the agreements, the contracts secret. They're claiming trade secrets, and if the details of these get out, it's going to undermine. They're going to lose value. They are damaged financially. It undermines the value of the contracts and the agreements. But at the same time, while all that is going on, we have continued leaks from and into the media, and it usually says ESPN sources say. So basically, what ESPN and the ACC are trying to do is they want to keep the agreement secret. However, they want to leak certain parts that are advantageous to them, okay, which is normal. That's just what you would expect. And Clemson is trying to push back on that. Clemson is saying, well, what you're doing is hurting us. It's making us look bad, so that when we do leave the ACC, you're trying to make it so that other media partners, other conferences might not want to bring us on board because we're the ones that are looking bad. So we'll see. I have a hard time seeing them actually getting any damages, receiving any damages. Yeah. But I think, again, in the whole settlement game of move, counter move, this is a way for them to kind of put some pressure back on the ACC, to try and gain some kind of advantage. But we use the word salacious. We like to joke around with that. Yeah. And that's usually what gets the headlines. It gets the attention. When you can accuse someone of some dirty dealings, and say you owe us money, like that gets the attention. So obviously, that's what's kind of getting the headlines. What's more interesting to me, much more, and I don't think you'll be surprised by this, we now have Clemson claiming sovereign immunity in the state of South Carolina.
Right.
There's been a lot made about Florida State claiming sovereign immunity in the state of Florida and how Florida has certain particular laws. And yeah, all the different states have different laws. And there's been a lot made. Okay, Florida State, they're burning bridges. Maybe no one's going to want them. We've talked about that before. Are they risking? Are they, are they causing some harm to themselves?
Longer term harm.
Yes, exactly. Well, now we have the second public university. Clemson's a land grant university, so we have the second basically the second university trying to leave the ACC. They're also a public university, and now they are also claiming sovereign immunity. Yep. I'm going to make a prediction here, JY.
Okay.
Every single public university that tries to get out of the ACC is going to claim sovereign immunity.
Sure.
And we'll see. And we may have different states have different rulings on that. We've talked about Florida in our other episode, the state of Florida, Judge Cooper saying that in Florida, you have to explicitly waive sovereign immunity. You can't just implicitly waive it when you're dealing out in another state. I don't know if Clemson has something like that on the books or some kind of precedent in the state of South Carolina. We'll see how that goes. But again, I'm going to predict we're now seeing a pattern. When something happens once, it's a one-off. When you start to see a pattern, it definitely tells you something. And I've told you this. You and I have talked off camera and during our episodes. For a very long time, before this case ever happened, I have always questioned public universities, taxpayer money, being involved in these secret deals, secret agreements. A lot of states have sunshine laws, public record laws, and to me, I've always thought, even before this particular, whether the Clemson case, the Florida State case, the ACC, that there was some problems there. And the thing is no one really ever challenged it. Right. You saw a little bit a long time ago with Miami and the governor of Florida getting involved. We're talking 10, 15 years ago. We saw some of it with Maryland, but it was just basically dabbling. Now we're really seeing two large public universities challenge on the base of sovereign immunity. This could be a huge game changer. We've talked about this. It could be a huge game changer on how conferences do these contracts with their media partners. Could have unintended consequences. We'll see. So to me, that is the biggest part of this, is Clemson now claiming sovereign immunity. The slander is salacious and fun. We'll see what happens with that. But I think that's again, sovereign immunity rearing its head again is the most significant part.
Yeah, and I absolutely, sovereign immunity is something we're going to continue to talk about until this thing's finally put to bed. To go back to the slander piece, I think the first part of that, it's all about the scope of the grant of rights, which was there, and you're going to hear me talk about this again. But that was kind of what they were getting at with their filing. We want to know what the scope of the grant of rights is. How far does it go? X, Y, and Z. They're definitely taking a step forward now with this malintent to harm Clemson, impairment of their intangible property. We'll see where that goes. I think that's hard to
prove.
Yeah. Absolutely. Unless there's something there where they maybe can prove it. I would say if they can, why didn't they have that in their first filing? And you can see now some of this back and forth. That we have two parties playing ball against the ACC.
Yes.
You see this crossover between both of them.
They're learning from each other.
We just talked about how there was the dismissal in Leon County. I know I've heard this gives a do-over for FSU. They can look at what Clemson did and maybe add some things. In reading this amendment, I felt like half of it was rereading the FSU lawsuit. Yep. They learned some things from that. And how, I shouldn't say learn some things from their filing, but learn some things from the hearings that have gone. And like, ooh, there's a hole. Yep. A potential hole. We don't know yet, but a potential hole. And we want to make sure if it is a hole, we're able to get our tiger foot into that hole. You know what I mean? So it was like 50% reading FSU's filing all over again.
And if I could make a quick point on there just to follow up with what you're saying. So we're seeing that now with Clemson entering the fray, and it's tempting to just say like this is a 2-on-1 situation. Yeah. So the ACC's risks are doubled. Well, I think it starts to the risk I think starts to increase exponentially as we get more schools that do this. If we have a third school, especially another public university in another state, enter this, then they're being attacked from all sides. So and they can use each other's filings. They can see and so the risk would just jump up exponentially against the ACC.
Well, use each other's filings and use other judges' opinions as to where there are issues here. So very interesting. So two other things I want to talk about here in Pickens before we get to Mecklenburg. The first has to do with the temporary seal and an order issued on that. The second is that the ACC on May 7th, so just a day or two ago, filed a motion to dismiss in Pickens. So we'll get to that here as well. So on May 1st, Clemson clarified their motion to temporarily seal agreements and laid out the reasons to enter a order temporarily sealing Clemson's unredacted complaint and the redacted portions of the amended complaint until a hearing is held to determine which of the portions should be and will remain sealed. They state that under South Carolina rules of civil procedure, the party seeking filings under a seal be served in a motion to seal that identifies with specificity the documents or the portion of the documents for which sealing is considered necessary, a description of those documents, and a separate attachment of the full agreement, unredacted, for the court to then review. On May 3rd, Judge Gravely issued his interim confidentiality order. It stipulates that from May 3rd until a subsequent order, sometime in the future, ACC's production of and Clemson's use of certain agreements between the ACC and ESPN that Clemson has requested be produced and be treated as confidential in their entirety until the court determines the appropriate protection. The ACC was given 7 days, which is until May 10th, to provide Clemson with the unredacted ESPN agreements. The judge lays out what should be done in the event a Freedom of Information Act request is made. I'm like, holy cow, we're thinking ahead here, Steve. He said you have two choices. Either the ACC can approve of that request. So this would be somebody's filing a Freedom of Information Act request to Clemson University. So either the ACC can say, yep, you can give it, which they're not going to do, obviously, or a court of competent jurisdiction can compel Clemson to do so. So it would have to go through the courts for the Freedom of Information Act, whatever courts those go through, and they would have to order Clemson to give these unredacted agreements. That could get sticky too. We'll see what happens. But as we've said, Steve, this for the ACC, this is all about following the process so that they can say to ESPN, we did everything we can to protect your confidential agreement. If the courts overrule us, There's nothing we can do about it. That's all this is about. And of course, ESPN doesn't want these things out there either. They've talked about that, trade secrets, yada, yada, yada. So anything on that before I go to the motion to dismiss?
I think this judge is opening a huge door, and well, he's placed a door there. It's closed right now, but he's telling people where the key is,
Kinda.
how to find the key and how to open this door, which I find really interesting because we've heard before is that the schools didn't actually have copies of these agreements.
Correct.
There was down in Leon County in Judge Cooper's court. One of the parties described that an ACC official flew the contract down, had the president of the university sign it and take it back, that they actually never got a physical copy of the contract.
Right.
We've heard all kinds of things.
Yeah.
But we know, as far as, they had 10 days, so by May 10th, Clemson was going to get a physical copy of the contract, which is technically confidential. The judge is saying it's confidential, but then he's also saying, but hey, if you want to file a Freedom of Information request, then a court can say yes or no on that. So I think it's really interesting.
And I just want to say, this is all about public. I see a lot of people, I said this on one of the previous episodes, where what's in these contracts? Oh, there must be all kinds of hidden gems in this thing. I'll be very clear and remind everybody, the universities and their attorneys can see these contracts. They have to go, yes, I get it, they got to go to North Carolina. They got to go to the ACC headquarters. They have to be in a special room with no cameras and blah, 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 blah. They have to do all this. But they can see them. I think some people are under this assumption that nobody's ever seen these things. Every member of the ACC has, or I'm not saying they have, they certainly could or can. It stipulates Clemson has gone and seen them. I think it's at least 2 times. So they've seen these contracts. People have seen these things. So all this hubbub and I see these people, oh, I really wonder what's in there. The members know what's in there. Now, they need the contracts to create a case and use them in a filing.
Yes.
100% they need them. But I just feel like we need to really tamp that down because everybody wants to go off their frickin' rocker about that.
I don't think we're going to... The Colonel's secret recipe for his fried chicken is not going to be in there, or the burial location for Jimmy Hoffa. So if people are expecting some kind of amazing thing in there, I think that's a little silly. And to add to your point, I think there's 7 schools that have sent their attorneys in the last year or so to view these and have taken notes or whatever. But the bigger point to what you're saying is, right now, all we have is leaks and rumors of what is in these contracts.
Correct.
The schools that are trying to get out, they want these contracts to be public record, public knowledge, so that they can attack both in the media and then also in their legal filings.
For sure.
Anything that they don't like about these contracts.
Good point. So let's get to the May 7th motion to dismiss in Pickens County filed by the ACC. They make several arguments here, Steve. First, that there is no personal jurisdiction over the ACC in South Carolina. They state that there is no general jurisdiction and there is no specific jurisdiction. Second item, the court should dismiss or stay under principles of abatement, comity, or forum non-convenience. They lay out several interrelated lawsuits over the validity of the grant of rights and mention the FSU lawsuits here. They state that the South Carolina Supreme Court has discussed comity and referenced a certain case. It was Sparrow versus Nerzig is the case that they reference here, that found that state action between that state action be abated until a federal court's actions were determined. So different cases, you're talking federal versus state in that, but they're basically saying the Supreme Court has shown that this case should be abated for the other case. They state that this case in North Carolina, that the case in North Carolina was assigned to the same judge and has already made significant legal decisions concerning North Carolina laws and jurisdictions. They conclude that if multiple jurisdictions conclude differently on the same issue, chaos will ensue. Thirdly, the court lacks subject matter jurisdiction over our good friend sovereign immunity.
Yeah.
To summarize this portion, the summarize says that Clemson is asking this court to do something that it cannot do, that is decide an issue of North Carolina jurisdiction. On May 7th as well, the ACC issued a brief in support of Clemson's motion to seal. This is to seal the redacted portions of the complaint and amended complaint filed in Pickens. They say these 9 paragraphs have highly confidential, proprietary, trade secret information from the ESPN agreements. They point out that the NC Business Court has found these to be properly redacted, and they state that Rule 41.1 of the South Carolina Rules of Procedures support granting the motion to seal. So I think for now, we fully understand both Clemson and the ACC are okay with this temporary. Now, Clemson's saying temporary, the ACC saying a complete motion to seal. But at least for now, we're under a motion to seal. Of course, we're going to have this dismissal hearing in South Carolina. We had them with FSU. We saw kind of how both of them went. The one part I did find interesting was the whole part now that we're getting into a second case that the ACC is bringing up abatement, comedy, these different things. And as they say, if multiple jurisdictions conclude differently, chaos will ensue. So we've talked about that for a while. What's going to happen? The ACC is putting it out there. I don't think it's enough for a dismissal here, but I do think it's an interesting point that they put forward.
Yeah, as far as the motion to seal, I don't really have much comment on that. But the part you were just talking about, as far as jurisdiction and all of that, the complaint that they're making that that the South Carolina courts do not have jurisdiction over the ACC. I think we're kind of seeing basically the ACC wants this to play out in South Carolina just like it played out in North Carolina. Mm-hmm. It's just a matter of contract law and normal contract between two parties. Here, the organization is based in North Carolina, so that's where the jurisdiction should be. What's going to be interesting is, and we don't know yet because we haven't had very many cues from the judge in South Carolina. Right. Is he going to have that Judge Cooper perspective where Judge Cooper was like, this is obvious, this is state of Florida property, this is where the jurisdiction is, this is very obvious. He kind of had that perspective, so it'll be interesting where the South Carolina judge goes with that.
Yeah, so we're basically getting set up for hearings here in Clemson. We know we're going to be a little slow here with the FSU stuff for a little while. We're going to spend the next month probably on Clemson hearings and things like that. So let's turn quickly, not nearly as much here, but to Mechlenburg County, North Carolina. A couple things filed on May 6th. One was Clemson's motion to dismiss and Clemson's motion to stay the actions in Mecklenburg. So let's talk about the motion to dismiss first. There will be a hearing on this on July 2nd. So we got a little bit of time to wait for a dismissal hearing in Mecklenburg. I would think, to your point, we've seen that. We kind of know how it's going to go for the most part. It's not exactly the same, but it's pretty darn close in Mecklenburg. The interesting part is going to be what happens in Pickens. But anyway, they're doing this dismissal. They gave 3 points on which they're requesting a dismissal with prejudice. 1 is the lack of personal jurisdiction. 2 is lack of subject matter jurisdiction. And 3 is failure to state a claim upon which relief can be granted. This is directed to all but one of the ACC's claims, basically saying, I think there were 7 total, so 6 of the 7, if I remember correctly, did not claim a relief in their filing. In their brief to this motion, they point out that the FSU case, and specifically the dismissal on the breach of fiduciary duty claim, but with the exception that these cases have notable differences and that the cases should have little bearing on this case. They state that no controversy exists because the SC action, the South Carolina action, only sought a determination on the scope of the grant of rights and the damages that Clemson has suffered due to slander by the ACC. So I talked about, the determination here is about scope, and they're saying to Mechlenburg, to Judge Bledsoe, there was no controversy, there is no controversy, we're just talking about the scope of the grant of rights. Again, we heard how that played with him with FSU, aka it didn't. They offer several arguments. Number 1, sovereign immunity. They argue Clemson did not consent to be sued in the court of North Carolina. Thus, Clemson's sovereign immunity has not been waived. They discuss South Carolina law. They discuss Farmer versus Troy, which was the big one that was talked about by Judge Bledsoe in North Carolina, which Clemson here says has a different set of facts. And they say the Hyatt case should control the outcome here. Same thing FSU said. We heard what Bledsoe had to say about it. The second argument, they offer several other deficiencies, which include lack of subject matter jurisdiction. It's kind of back. They're both saying the same damn thing about each other. But anyway, lack of subject matter jurisdiction. Estoppel claims are not independent offensive claims, and a claim was not stated. There's no material breach of the grant of rights. Clemson owes no fiduciary duty to the ACC. And then with their motion to stay, Clemson filed this in North Carolina, and they talk about this lawyers' mutual factors weigh in favor of deference to the first filed. And of course, Clemson filed first. So it's just the reverse of what we saw with FSU, that whole priority argument. Yes, the ACC got it in first. Bledsoe said, yep, you're good. It'll be interesting to see what Bledsoe says here, because the ACC does not have the priority argument with Clemson. So that is probably the most significant difference in terms of how these hearings and how these filings went. Last thing, May 7th, Clemson filed a brief in opposition to the ACC's motion to seal. The public is entitled to view all court documents, they state. They also say the ACC's proposed redactions are arbitrary, inconsistent, and overbroad. And then third, the court should reject to hide the representations, warranties, and other common provisions that are in the ESPN agreement. I read this and I went, that sounds exactly what Judge Bledsoe said when he ruled on the motion to seal with FSU. Verbatim, that's basically what he said. So again, you're seeing a lot of this overlap. Anything there with the motion to the motion to dismiss in Mecklenburg for Clemson.
So overall, with this, what you were just going through, I think we're going to most likely just see a repeat of what we saw with the FSU case here in Mecklenburg. I think there are two opportunities that maybe we'll see something different. You touched on one, priority. Mm-hmm. Because Clemson filed first, we'll see. Judge Bledsoe might just say, well, in this case, it's a similar case to our other one, and they've been combined.
Right.
So since the ACC was the first one to file against Florida State, and now this is being combined with that, we're just going to keep the priority from the very first filing. So as not to, because otherwise, if you keep having multiple suits, multiple states, it does create confusion and chaos. Yep. So he may say that the original case was here, filed here, that's where we're going to keep it.
And it gets back to the whole comedy issue that they're trying to say in South Carolina. Right. I think that, to your point, I think that will play with Bledsoe because it's the same thing.
Yeah.
And I'm already hearing this. So on an issue of comedy, we'll just combine them and we're going to keep it going. That could be his easy out.
Yes.
I agree with you.
The other area where I think there is an opportunity to differ is controversy. We talked about Florida State signaled this from the top of the highest mountain that they were going to sue. You had Board of Trustee members who were making salacious quotes, putting them out there. They signaled as clear as could be that they were getting out and they were going to sue. Clemson did this a whole lot more quietly.
Yeah.
So they have a lot more. They have more of a leg to stand on when they're trying to say there's no controversy.
Good point.
We'll see if Judge Bledsoe agrees with that or what he thinks of it. But they probably have more of an opportunity there. That's really my only thoughts on that.
Well, and Bledsoe was very clear about how there was a controversy with FSU and was citing certain things. This has been going on for a while. Blah, 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 blah. He can't really say that with
not as clearly
as cut and dry.
Yes.
So yeah, I think two very large differences here in Mecklenburg if he chooses to move forward with this. But like you say, he's kind of already hearing it. Does he combine them? We'll find out. But I think for the Clemson side, what's going to be more interesting, because they are behind the 8 ball, or they're behind the case for FSU. So we're probably going to continue to follow the FSU case in Mecklenburg. It's going to be the driver of that. Clemson will probably be focusing mostly on Pickens County, because that's specific, much more specific to the Clemson University ACC lawsuit. So with that, a lot to go over. We warned you things were going to happen, and boy, did they. I have a funny feeling there will be many more coming up here in the next couple of weeks. We do have to wait until July for that daggone hearing, but that'll be here before we know it. I mean, it's summertime. We'll be on vacations. Before you know it, it'll be hearing, and then we'll be into college football. So, Hey, with that, thank you guys for watching. Make sure you like this video. Subscribe if you like our content. We do everything college football, and especially the lawsuits surrounding the ACC. We'll see you guys next time on The Big Mountain.
Clemson's starting to get salacious.